Okay, you're live now.
Good day, everyone. Thank you for joining us on today's webinar organized by Punuka Attorneys and Solicitors. Today's webinar is themed A Global Outlook on Ease of Doing Business. Can CAMA 2020 sail us through? My name is Sani Efi Omolade. I'm an associate of Punuka Attorneys and Solicitors. I'm based in the Abuja branch of the firm. I'll be moderating today with my colleague, Ms. Florence Ojewumi. Punuka Attorneys and Solicitors is a leading law firm working with you for solutions. We currently have 3 offices in Nigeria with connections to other law firms across the globe. The firm consists of 5 partners, over 30 lawyers with over experience in over 12 sectors and 16 practice areas, such as the capital market, tax, company secretariat, energy, and the business and regulatory practice group, amongst others. To know more about the firm, kindly visit our website, www.punuka.com. Also, follow us on Twitter, Instagram, and LinkedIn at Punuka Attorneys for current updates on the firm. This webinar was put together by the Business and Regulatory Practice Group of the firm. Through this webinar, we shall consider the strengths and weaknesses of the CAMA 2020 in easing doing business in Nigeria and how it affects other sectors of the Nigerian business sector. A discourse will be made on efforts of the federal government and the Corporate Affairs Commission in achieving the goal of easing business in Nigeria. For purpose of this webinar, we have 5 speakers who will be speaking on different topics centered around the CAMA 2020. This promises to be interesting, educative, and interactive, and we urge you to stay with us. Before we begin the business for the day, I'll go over a few housekeeping rules for the duration of this webinar. This webinar is scheduled to hold for 1 hour, 20 minutes, and we intend to stay within that time. Each speaker have 10 minutes to make their presentation. All participants join in muted. So if you have any questions, kindly leave your questions in the Q&A box, and be sure that all questions will be taken after presentation by every speaker. In respect of your questions, you can also direct your question to a particular speaker, and we will try our possible best to take all questions that time will permit us to take. I will immediately call on my colleague to introduce the first speaker for today, and as we begin this webinar. Thank you very much for joining us.
Florence, you've been muted all along. You have to unmute your mic.
Thank you. Thank you very much, Ayo. Welcoming everyone once again, and thanking my colleague, my co-moderator, Omolade Sani, for the succinct presentation and introduction. Right now, I'll be welcoming and introducing Mrs. Gloria Ogu to make a presentation on the overview of CAMA 2020. CAMA 2020 will be, the overview of the subject matter will be discussed. Mrs. Gloria Ogu is the head of business and regulatory of regulatory team of Punuka Attorneys and Solicitors. Mrs. Gloria, please kindly present your PowerPoint. Thank you very much.
Thank you very much, Florence, for the introduction. Thank you very much, Molade. Today, I'll be speaking on the notable reforms under the New Companies and Allied Matters Act, also known as CAMA 2020. In giving an outline of this act, I'll start by saying that the act is made up of 870 sections as opposed to 613 sections under the former act. It's also divided into 7 parts as opposed to 4 parts under the former act. Part A now deals with the composition of the Corporate Affairs Commission, while Part B deals with the incorporation of companies as they relate to the various forms of companies registrable in Nigeria. Part C and Part D are quite novel because we see the introduction of the registration of limited liability partnerships and limited partnerships at the CAC. Part E, which was formerly Part B, now deals with registration of business names and provisions as they relate to business names, while Part F deals with the registration of incorporated trustees as well as provisions that guide incorporated trustees in Nigeria. Under Part G, we see general provisions under the Act as well as the establishment of an Administrative Proceedings Committee, also known as the APC. By way of introduction, I'll start by saying that the President on the 7th of August 2020 assented to the CAMA bill, which was recently passed by the National Assembly. This new act is not an amendment of the former act, but is a repeal. Also, by virtue of the Interpretation Act of Nigeria, the act is deemed to have been passed on the same day it was assented to. It's however important to note that this CAMA 2020 is yet to be gazetted. In highlighting some of the reforms under Part A, I'll start by saying that the CAC under the new act is now empowered to conduct or arrange an investigation into the affairs of any company, incorporated trustee, or business name, where the interests of the shareholders, the members, the partner, or public so demands. The CAC is also empowered to undertake activities as a necessary or expedient to give full effect to the provisions of this act, such as making regulations that would guide companies, incorporated trustees, and business names alike. We also see the introduction of a requirement of a 30-day pre-action notice before any action can be brought against the CAC. In moving on, I'll be highlighting some of the reforms under Part B of the Act. We see a very welcome development by way of the introduction of single-member shareholder for private companies. This is great for startups as well as SMEs. Also, in respect of companies limited by guarantee, we also see the introduction of an alternative to the aegis consent, where same has not been obtained within or granted within 30 days. The promoters of such company limited by guarantee can now place an advert in 3 national dailies and invite objections within 28 days. We also see the replacement of the authorized share capital with minimum issued share capital, which shall not be less than 100,000 in the case of a private company and 2 million in the case of a public company. The Minister of Industry, Trade and Investment is now empowered under this act to prescribe model articles, thereby allowing for different model of articles for different companies. CAC is also empowered under the act to, at any time before a certificate of incorporation is issued, to withdraw or cancel a reserved identical name. The statement of compliance of an applicant is now obtainable as opposed to the declaration of compliance previously. Hence, an applicant or his or her agent can now attest to the statement of compliance at incorporation of a business. Under this new act, the CAC is also empowered to withdraw, cancel, or revoke a certificate of incorporation which was obtained fraudulently, unlawfully, or improperly. Foreign companies can now file an application for exemption directly to the Minister of Trade. Another welcome development is that company seals are no longer mandatory. This has been done away with in other jurisdictions. We also see the introduction of electronic signatures of an officer of a company, which is now deemed satisfactory in cases of authentication or service of documents. A public company under the new act can now be re-registered as a limited company. Disclosure of capacity by any person with significant control now applies to all companies and is no longer restricted to public companies alone. The CAC is also mandated to keep a register of such persons upon notification. We see also under the new act the provision for electronic transfer of shares. This is highly welcome and promotes ease of doing business. We see a non-prohibition of a company, a private company, from giving financial assistance in the case of acquisition of its own shares. A limited liability company can now acquire its own shares, including redeemable shares. Another highly welcome development is that the registration of filing of charges under the new act has been reduced to about 0.35% of the value of the charge, with a projected 65% reduction in the associated cost payable. In respect of small companies or companies having single shareholders, annual general meetings are no longer mandatory for these companies. Virtual meetings can now be held by private companies in Nigeria. However, this must be done in line with the Articles of Association of such private companies. Small companies are also further exempted from having their annual and statutory general meetings taking place only in Nigeria. Although already in practice, we see now that the CAC is now the party entitled to receive notice of general meetings of a public company. Also, service of notice by email is now obtainable in addition to personal service or service by post. Compensation of managers of a company is now to be disclosed to the members of the company at the annual general meeting. The chairman of a PLC, that's a public company, is now prohibited from acting as a CEO of such company. Also, a public company is to have at least 3 independent directors. Moving on, I'll be highlighting also some of the reforms under Part B, which include the disclosure of multiple directorships by a person to be appointed as a director of a public company. Also, we see the disqualification of a director who has been removed before the expiration of his tenure from becoming the director of any other company. Also, a prohibition of a person from being a director in more than 5 PLCs at a time has been included under the new act. A private company, which is a small private company rather, is now exempted from appointment of a company secretaries. Contrary, PLCs and their directors are now liable to a fine where they fail to appoint a company secretary. Under this new act, special protection is now being offered for directors' information, particularly information on residential addresses. PLCs are now mandated, although already in practice, PLCs are now mandated under this act to keep their audited accounts displayed on their website, in addition to hard copies. PLC's accounting statements must now include a statement in changes in equity. The definition of a small company under this new act has been expanded to include a private company with a turnover of not more than 120 million naira and net asset value of not more than 60 million naira. We also see under the new act the exemption of small companies from having the auditors being appointed by the company. Further exemptions in respect of private companies also include the exemption from preparing audited financial statements where a company has not carried on business since incorporation or is a small company. It's however important to note that insurance companies and banks do not fall under this exemption. We see further exemptions in respect of annual returns whereby small companies or companies with single shareholders are no longer mandated to file annual returns. It's important to note now under the new act that the failure of a company to file its annual returns for a consecutive period of 10 years is now the ground for striking out the name of such company from the register. Companies are now mandated to publish the list of unclaimed dividends as public companies in at least 2 national dailies and attach the list as published to the notice of the next annual general meetings. In respect of dividends under this new act, we see that dividends which have been unclaimed after 12 years can now be included in the profits which can be distributed to the shareholders of the company. A company can now be wound up by the court where the condition which necessitated its existence or operation has ceased to exist. Also, in terms of business rescue, we see under the new act, which is highly welcome, the introduction of voluntary arrangements, administration, and netting. The threshold amount upon which a creditor can present an application for winding up of a company has been increased from 2,000 naira to 200,000 under the new act. Also, in respect of qualification of an insolvency practitioner, the act, by virtue of section 705 sub 1, now describes a qualification for an insolvency practitioner to include a person who has obtained a degree in law, accountancy, or any other relevant discipline from a recognized university or polytechnic within a minimum of 5 years post-qualification experience in matters relating to insolvency, as well as obtaining the certificate of membership issued by the Business Recovery and Insolvency Practitioners Association of Nigeria, also known as BRIPAN, or any other professional body recognized by the CAC. The classes of persons who can now apply to the court for winding up of a company has been expanded to include directors. In respect of audit committees, we see under this new act that audit committees shall now consist of 5 members, comprising of 5 members of that company and 2 non-executive directors. All the members of the audit committee shall be financially literate, and at least 1 member shall be a member of a professional accounting body in Nigeria. I stated earlier, we see novel introductions under Part C and D respectively. We deal with limited liability partnerships and limited partnerships, which were not under the former act, were not registrable at the CAC. Now, partnerships under limited liability partnerships are to be governed by the CAC. Also, under the new act, we see the provision for foreign limited liability partnerships. Under Part D, we see that limited partnerships are now registrable. A limited partnership is not to consist of more than 20 persons to be called a limited partnership, whereby you have one or more persons acting as general partners who shall be liable for all the debts and obligations of the firm, and one or more persons called limited partners. In moving on, I'll be highlighting some of the reforms under Part G of the Act. We see the introduction of a classification of trustees according to their aims and objectives. We also see an introduction of merger of trustees, whereby two or more associations having similar objectives can now seek to be merged. Although quite controversial, Section 839 of the Act now empowers the CAC to, upon obtaining a court order, suspend its trustees, the trustees of an association, where it is deemed by the CAC, that's the Administrative Proceedings Committee, that the affairs of such association are being run fraudulently, or there's a mismanagement of the affairs of such association, or in the interest of protecting the property of such association, or for public interest. We also see that the CAC is now empowered to direct transfer of credits in dormant banks under the new act. A very welcome development is also the introduction of the biannual filing of statements of affairs in respect of incorporated trustees. Now, under the Part G of the Act, we see some reforms which I would say are very welcome in respect of now CTCs of electronically filed documents are now admissible in evidence. Also, the establishment of an administrative committee, administrative proceedings committee, like I highlighted earlier on. Under this new act, a person or association of persons shall not carry on business in Nigeria as a company, limited liability partnership, limited partnership, or under a business name without being registered under the act. Thank you very much.
Thank you, Mrs. Gloria Ogu, for that brilliant presentation, taking us around through a very bulky piece of legislation in under 10 minutes. Thank you very much. If you have any questions for Mrs. Ogu, kindly leave the question in the comment section, and be very sure that we'll take that question as soon as all the speakers have taken their paper. Without wasting time, we'll move on to the next speaker, please. The next speaker is Mr. Justin India. He is the Director, Board Secretariat of the Corporate Affairs Commission. He is representing the Registrar General of the Corporate Affairs Commission, the CAC, Alhaji Abubakar Garba. Mr. Justice India has years of experience working with the Corporate Affairs Commission here in Abuja, and he will be speaking on the role of government and the Corporate Affairs Commission in ensuring the smooth enforcement and application of the new CAMA 2020. Over to you, Mr. India. Thank you.
Good afternoon. Can you hear me?
Yes, please.
Yes, Mr. India, we can hear you.
Okay, okay. Well, it's a pleasure to be here. Good afternoon, everyone. I would speak on the role of Corporate Affairs Commission representing government in the smooth enforcement and application of CAMA 2020. I don't intend to read the slide, but I will try as much as possible to speak to the slide. Now, one thing we all agree to is that the role of government actually is to govern, and the role of business is to do business. Now, what that means is that government should concentrate on its role of being a facilitator and not involve itself in the management of business. That philosophy or approach we have seen in CAMA. So what CAMA essentially seeks to do is to promote the ease of doing business and to hand over the running of business to entrepreneurs. Now, we clearly see that in the approach that was adopted in the Act. The previous speaker has already spoken about several innovations that have been put into the new legislation. Now, what we could see from the study of the provisions of the Act is a clear attempt to actually open up the business landscape for entrepreneurs. And that we see in not only promoting the ease of doing business, but in also trying to bring in new business management organizations. So we have seen that the Act has introduced the concept of one-man company. It has also introduced limited liability partnerships and limited partnership, which before now was not available in the country. So that's an attempt to liberalize the business sector for entrepreneurs. And what the Act also tries to do is not only to liberalize, but it has tried to do so in accordance with the requirement of international best practices. So what we could have seen is a clear attempt not only to liberalize the business landscape, but to also bring in developments that have occurred in other parts of the world. So that is what we have seen. The previous speaker have already enumerated so many of them. Now, having said that, I would like quickly to go to the role of the Commission in implementation of CAMA 2020. Now, the functions of the Commission are clearly spelled out in Section 8 of the Act. And what we could see from Section 8 is that it tries to give the Commission power not only to regulate the formation of company, but to ensure that the companies that are registered are properly managed. And if there is a need for a company to exit the system, that company should also exit orderly from the business landscape. So we can see from inception that from formation to registration, up to management and winding up of company, the Commission is involved. We have also seen in Section 8, subsection 1D in particular, that the Commission is to ensure that all the entities that are registered under the Act comply with the provisions of not only the Act, but subsequent regulations that will be made by the Commission. Now, what that means is that the Commission should not only administer the Act, but it is also expected to prescribe regulations that will ensure smooth implementation of the Act. Now, as soon as Mr. President assented to the Act on the 7th of August this year, the Commission established an in-house committee that will bring up a draft regulation that will ensure the implementation of the Act. Because when you study the provisions of the Act, you will see that the Commission has been empowered not only to prescribe forms or to prescribe other processes that will ensure smooth implementation, but it is also expected to prescribe fees, penalties, and even fines that will be administered by the court. So the in-house committee produced a draft regulation. The board is expected to meet and approve the draft regulations next week before it is exposed to members of the public. So that we have seen is part of the responsibility of the Commission That is one, not only to ensure proper administration of the act, but to also develop supplementary legislation that will ensure smooth implementation of the act. Now, like I've said, that draft is ready. It will be considered by the board. As soon as the board approves it, it will be exposed to the members of the public for comments before it is finalized. Now, having said that, we could also see that additional responsibility of the commission is not only to ensure proper administration of the act and to develop regulations, but it is also expected to provide a conducive digital environment, because when you look at the whole gamut of the act, it presupposes that almost every transaction will be done electronically. So what the commission will do in addition to prescribing regulation is to also ensure that there is a robust application on which all pre and post incorporation will run. So the thinking is that as soon as implementation starts, almost all processes of the commission will be electronic, and nobody would have any reason to come to the commission. You will be able to do all transactions from the comfort of your home or from your office. So that the commission is already doing. It is already developing the relevant software that will ensure that customers and any other person that will have reason to deal with the commission will do so electronically. So these two basic functions of the commission is what we will call a transition responsibility. After the act has come into effect fully, then the commission is expected to play its role as a regulator, as we have seen in the body of the act. And the commission would like to encourage the members of the public that it is aware of its responsibilities, that it will try to encourage genuine and honest businessmen to do their work, and therefore it will, while playing its responsibility as a regulator, seek to facilitate the promotion and development of business, and will only resort to the big stick where and when it becomes absolutely necessary. So that is the few remarks that I want to say on the promotion or on the role of the Corporate Affairs Commission in implementation of CAMA 2020. I believe there will be questions from members of the public which will be ready to respond to. So I thank you for the opportunity given to me to make this small presentation. Thank you very much. Yeah, I'm done.
Please, Florence, unmute.
Thank you very much, sir, for the succinct presentation. We really appreciate it, and we appreciate the, the various aspects you've highlighted. The fact that, the Corporate Affairs Commission have worked on the guidelines to accentuate the present regulation and also to prescribe, various ways of applications in terms of, prescription of fines and penalties, and other rules on costings and all that. So we really appreciate this presentation. And now I'll move on to introduce to you our next speaker for today. She is the managing partner of Punuka Attorneys and Solicitors. Her name is Mrs. Elizabeth Idibe. I'll kindly make welcome to the podium, Mrs. Idibe, to make our presentations. Thank you.
Thank you very much. So my paper will be speaking on the provisions of the new CAMA as it relates to corporate governance, which is an area that I'm very passionate about. I will be speaking about the concept of corporate governance, the history of corporate governance in Nigeria, understanding corporate governance, and then understanding the CAMA 2020, as it relates to corporate governance. And I would specifically mention the issue of corporate governance as it relates to incorporated trustees. And then I will conclude. I believe the CAMA 2020 is a framework that encourages ease of doing business in Nigeria. It's a very welcome legislation. And one of the ways to ensure you can do business easily is to imbibe good corporate governance. Because it's only when you have good corporate governance that you can engender, stronger institutions. And then of course, with stronger institutions, you would engender investments, and then there'll be growth in the economy generally. And so over the years, this issue and subject of corporate governance has been changing, but the message remains the same, that it's about accountability, it's about responsibility, and it's about integrity. So every nation would pursue the corporate growth, because for you to do that, you must emphasize, for a nation to pursue corporate growth, it must emphasize corporate governance development. And so the new CAMA, this did a lot in this regard, and I would be discussing these provisions. First, I'll go to the history. First, I have this design, I have the anatomy of corporate governance, or the concept of corporate governance. And generally, you can see that when you talk about corporate governance, you're talking about having a strong board of directors and having, the board having committees that can effectively function, because it's at that level that a lot of decisions and things are analyzed properly. And then you look at the legal and regulatory framework, and then you look at the organizational hierarchy. And then, because of course you have to have succession planning, ensure that you have right people to take over from the present members of the board and management. And then you have the monitoring and internal controls. It must be very strong. And then of course, the policies and procedures must be in place. If you don't run with procedures and policies, you cannot have a strong company with good corporate governance. And of course, at the end of it, there must be transparency and accountability. And I would emphasize that this, what I have here, just emphasizes what some people refer to as the 4 Ps of corporate governance, which will be the people, the process, and the performance, and the purpose. So this actually, emphasizes, and addresses the 4 Ps of corporate governance. Corporate governance dates back to the 16th century and the 17th century. And when it became so very obvious and became very key was after the Enron saga in 2001. The standards became higher to ensure that companies had adequate financial reporting, transparency amongst company management personnel and board, identifying the shareholders and directors of these organizations, then introduced dynamism in respect of board structures, and of course the issue of diversity of board members in terms of gender, professional, the professions that they belong to, and then of course balance of power amongst the different corporate stakeholders. That would include the shareholders and the directors and even employees. So now I want to just take you quickly through the history of corporate governance in Nigeria. So first we had the Companies Act of 1968. This was modeled after the Companies Act 1948 of the United Kingdom. Now this was repealed and replaced by the Companies and Allied Matters Decree number 1 of 1990, which was consolidated in 2004 under the laws of the Federation of Nigeria, Federal Republic of Nigeria, and it was referred to as the Companies and Allied Matters Act, Cap C20, 2004. A lot more could have been done in this act to adequately address the issues of corporate governance. So there was a lot of gaps. It didn't really address a lot of these issues of corporate governance. So it was imperative that this gap had to be taken care of, particularly with what happened in the 1990s, and early 2000. Even in Nigeria, lots of banks went under, and SEC, Securities and Exchange Commission, decided to take the lead and came out with a code of corporate governance in 2003. It was to regulate only the public limited liability companies. And that code made a lot of impact, but it was mainly persuasive and not mandatory. Now, this code, SEC code, was amended in 2008, and its emphasis was on creation of strong board of directors to practice good corporate governance. This again was limited to public companies, and other companies were encouraged to practice the principles where appropriate. In 2011, the SEC code was further amended, and still made an impact. 2006, CBN released its code of corporate governance and to ensure accountability amongst banks, because CEOs, and because generally we remember the collapse of many banks in the early 2000 and late 1990s. And so CBN also decided that it was important to come out with a corporate governance code. So you have others. You have the 2008 National Pension Commission. You have the NICOM 2009 code, and then you have the FRCN Nigerian Corporate Governance Code 2018, which was the most prominent until CAMA 2020 came into was promulgated. Now, the grand law of corporate governance, as far as I'm concerned, is the new Companies and Allied Matters Act 2020. This act sets a different standard, and it has done a lot in terms of corporate governance. And if corporate companies adhere to it, I think the country will be better placed in terms of having strong corporate bodies. And of course, that will attract investors into Nigeria. So I'll go on straight to talk about some of the provisions that this new CAMA 2020 has put in place to actually emphasize good corporate governance. First, I'll talk about prohibition of an individual from holding the office of chairman, CEO, in a public company. So section 265 sub 6 prohibits one person from holding both the position of chairman and the chief executive officer stroke MD of a public company. Now, this requirement is stated in item 3.3 of the Nigerian Code of Corporate Governance, 2018. Now, this new act now makes it mandatory, because like I said, the Nigerian Code of Corporate Governance was mainly, it was persuasive, not mandatory. But now this is mandatory, and this is to encourage checks and balances in the management of the company. And I think it's a very welcome position. Then provision for independent directors. Section 275 of the new CAMA provides that public companies would have at least 3 independent directors on their board. Now, the SEC Code of Corporate Governance for public companies and the Nigerian Code of Corporate Governance provides that companies would have a minimum of 1 independent director. Now, to ensure compliance, public companies that already have 1 independent director are required to appoint more independent directors in compliance with the provision of the law. Section 2753 of the Act further defines who an independent director is, while Section 7 of the Code prescribes criteria for establishing the independent status of an independent non-executive director. This code clearly defines who is an independent director. Also, I will talk about what it defines, that's under this section 2753. It just tells you who an independent director is. The person, it says the Act defines an independent director to mean a director of the company who or whose relatives, either separately or together with him or each other during the 2 years preceding the time in question, was not an employee of the company, did not make to or receive from the company payment of more than 20 million naira, own more than a 30% share or other ownership interest, directly or indirectly, in an entity that made to or received from the company payment of more than the amount stated as a 20 million naira, or act as a partner, director, or officer of a partnership or company that made to or received from the company payment of more than such amount, did not own directly or indirectly more than 30% of the shares of any type or class of the company, was not engaged directly or indirectly as an auditor of the company. Clearly define who a non-executive independent director should be. And that makes it clear who you should put in there on the board to play that role. Then the issue of audited account to be displayed on company website is another welcome development. This is provided for in section 374 sub 6 of CAMA. It requires every public company to keep its audited accounts displayed on its website. So it syncs with an existing requirement of the Nigerian Stock Exchange and SEC to have this done. So it encourages communication between stakeholders of the company and the other stakeholders and other investors of the company on the activities of the company. It will also enhance accountability and transparency as stakeholders are able to follow through and monitor their company's growth and development. New investors can refer to this in carrying out due diligence and determine whether or not to invest. So this is also very important. Disclosure by persons who hold significant control in a company. I think this is really good because section 119 and 120 of CAMA provides that persons who hold significant control in any type of company are required to disclose particulars of such control to the relevant companies within 7 days of acquiring such significant control. All affected companies must inform the commission within 1 month of receipt of information. This is very important. So because corporate governance is about who runs the company. It's even more important sometimes to know who is behind the company than even looking at the financial statements, because you want to know whether these are people of integrity, people you can do business with, and this provision actually encourages this. Disclosure of multiple directorship. This again is provided for in section 2782. And it makes provision for disclosure of multiple directorship held by any person to be appointed as a director of a public company. It actually states clearly that you cannot be a director in more than 5 public companies. And this is good because people sometimes take directorship thinking it's just another addition to the qualification. But the reality is that being a director of a company is for you to be responsible, to participate, to ensure that the company is well run. And this is to ensure that people have enough time to give to the affairs of the companies where they sit on their board. Very welcome and very good development for corporate governance. Now the provision talks about the company secretaries not really very needed for optional now for small companies. Well, Section 8 of the Nigerian Code of Corporate Governance highlighted the role of the company secretary. What they do as what company secretaries do to support the board. It mandates that the board should probably empower the company secretary as well as approve his or her performance evaluation, appointment, and removal. Now, this section 330, that's 330 of CAMA, provides that it's no longer mandatory or optional for small companies. Once I understand the fact that this CAMA is to ease the business, to encourage ease of doing business in Nigeria, I believe that it is also important that company secretaries be appointed if you want corporate governance to be adhered to. So I am a big, I think that this provision should be looked at again, but I understand why they're saying they want to save money for small companies. Prohibition of secret benefits, this also was stated clearly in 313, prohibiting directors from accepting bribe, gifts, or commission. Disclosure of managers' remuneration, this is also stated in 257. Please move fast. I think I'm going beyond my time. I need to rush this. Then the suspension of trustees and appointment of interim managers, and this is provided for in 839. So it's no longer business as usual for incorporated trustees. Now there's a lot of searchlight And where you don't do the right thing, you can be removed and an interim manager would be appointed. So please go on. Then the commission would, although empowered to take decisions that affect incorporated trustees, can only do so upon an order of court and the approval of the Minister of Industry, Trade and Investment. So there's still some right to fair hearing. So it's not like they just do that without going through the a fair process. Then biannual filing of annual returns. I believe Gloria touched on this when she did her overview. This is also welcome because now you can clearly know what these corporate trustees are doing, because now they file twice in a year. Then transfer of credits in dormant accounts. Of course, this is also encouraged because people should not collect money from, because most of these corporate incorporated trustees, most of them are charities, and you don't collect money just to keep it there in an account and you're not using it for the purpose you want it to be used for. The commission can actually, with the bank, ask the bank to, to transfer this to them if you are not using the funds there. You just don't leave it in the account. Then I will conclude by saying that the provision of the Nigerian Code of Corporate Governance 2018 and the SEC Code for Public Companies did a lot, and I acknowledge a lot of things they did to put in good corporate governance in the companies. However, I need to state clearly that where there's any conflict between these codes that were existing and the new CAMA 2020, of course, CAMA 2020 would prevail because these legislations are subsidiary legislations, whilst CAMA 2020 is a substantive legislation, mandatory in nature, and penalties for non-compliance with its provisions are clearly stated. These provisions intend to promote transparency and accountability on the board. It also wants to reduce financial mismanagement. It encourages capital investment and economic growth and adherence to the provision of the law. Thank you so much. Thank you.
Thank you very much, Ma, for the presentation. Thank you so much for running us through the CAMA 2020 as it relates to corporate governance. I know that you've highlighted, the purpose of corporate governance. You highlighted the 4 Ps, and you also highlighted the fact that the history of corporate governance and how the crisis in the 90s and in 2000s sort of make the whole world come to terms with the fact that, see, we have to have standards in place, standards to check the members of the board, the director, senior management, and other staff of the company. Thank you very much, Ma, for that wonderful presentation. Now, I want to tell the audience one more time, if you have questions, please put your questions on the chat so that we can, start to ponder through and be able to answer your questions. Now, I'm going to invite to the podium. I call this the electronic podium, right? Because the pandemic has made everyone, to really adapt to doing things differently, which is doing webinars and presentations and trainings online. So I welcome to give us a presentation, Mr. Folari Aluko. Mr. Folari Aluko was the former chairman of the NBA, Nigerian Bar Association, Abuja Unity Branch. And he'll be speaking on how lawyers can work with the CAC to see a smooth implementation of the new CAMA. Please make welcome with me, Mr. Folari Aluko. Thank you very much.
Okay, we would be wasting too much time because from the look of things, Mr. Folari is currently not available. So we would immediately be proceeding to the next paper in view of time and making sure we complete this webinar at the time we said we would complete. The next paper will be taken by Anthony Digbe, SAN, who is the senior partner of Punuka Attorneys and Solicitors. a seasoned legal practitioner with over 35 years legal experience. His paper will be on the international perspective on the ease of doing business, UK, EU, and Canada approach. Can CAMA 2020 sail us through? Leonard Silk, we are ready for your paper, sir. Thank you.
Thank you very much. And my apologies on behalf of Larry. I saw him, but on the panel, but I think maybe the technology must have failed him with internet challenges, etc. So my apologies on his behalf. As soon as he's able to come back, we should be able to take him. Can we go to the next slide, please? In summary, I will just give a short introduction, then I would look at the role of the new CAMA, as well as the other regulatory reforms that are required to complete the ecosystem of ease of doing business. And then I would do a review and conclude. The next slide. Now, the government objective of ease of doing business was declared by President Buhari, and he stated that he wants Nigeria to be number 70 on the World Bank Index of ease of doing business by the year 2023. To achieve this objective, he set up PBEC, which drove the agenda of ease of doing business under the office of the Vice President. And PBEC played a pivotal role in delivery of CAMA 2020, working with the CAC and other stakeholders, such as the section on business law of the MBA and BRIPAM. So what's the significance of CAMA 2020? I think a lot of it has already been said, but in summary, we would say that the objective, as has been so well laid out by Justin, is to reduce the cost of registering a business and including new forms of business structure, as well as achieving operational efficiencies. And then the second significance is the introduction of new business rescue mechanisms, which, I think Gloria discussed, and then improvement on the insolvency option to remove zombie companies from the system and prevent them from polluting the system. And then there is introduction of regulation for insolvency practitioners to improve standards. And then, of course, corporate governance, which has been so ably discussed by the managing partner. And then there's, of course, the issue of the incorporated trustees and regulation of tax-exempt status institutions. The next slide. So in terms of the ease of doing business, we need to recognize that CAMA alone cannot achieve the ease of doing business. And the World Bank in their 2020 report identified many areas apart from the structure of business that would achieve ease of doing business. And they include simple issues like making sure people have access to electricity, dealing with the process of obtaining construction permits, the process of registration of property, transfer of title, obtaining credit, particularly ability to obtain credit using mobile assets, protection of minority investors, where this will come under CAMA, the workers' employment and terms enforcement of contracts, which is a rule of law issue, resolving insolvency, part of which is dealt with in CAMA, the payment of tax, because without tax, the government cannot work, and that means, considering investment in that area, And then the ease of trading across borders, which has something to do with enforcement of contracts, and also the ease of contracting with business. In other words, the public procurement process. So once we get that in context, you know, that look, it's not just an issue of how you set up a business and run it that determines ease of doing business in a country. Then we can drill down to say, okay, so what is the contribution of CAMA 2020 to this whole ecosystem? And I think a lot has already been said, so I will try not to repeat it. That first, that there's a clear focus on reduction of cost of doing business and barriers of entry into becoming an entrepreneur, and which you would see with the new provisions of single shareholder, minimum number of directors, you know, statement of compliance rather than affidavit, which will take a longer procedure, replacement of authorized share capital with minimum share capital, which releases money which would have been tied on payment of stamp duty, you know, for capital that you don't really require, you know, and you haven't called, you know, exemption from audit and annual general meeting for small companies, elimination of the requirement of appointment of company secretary for small companies. And I don't think there's any conflict between these reductions for small companies and the necessity for, say, company secretary for big companies, etc. Because really, you know, the small companies may not necessarily require some of these additional structures, even though, well, if you want to run your small company very well, it's advisable, as has been said, that notwithstanding the fact that it is not a legal requirement anymore, as the managing partner advised, if you want to run it efficiently, it may be good to still have a company secretary. So it's just that it's not mandatory. So let's go to the next slide, because there are so many of these concepts have already been discussed. The issue of digitalization of the processes have been discussed, and we have been told by the Corporate Affairs Commission that they intend to invest massively in technology to ensure that everything is electronic, that you have absolutely no need to go to the CAC. And I believe right now they are trying to force themselves to change by already insisting that nobody is welcome there physically, and you have to communicate with them either by email, by courier, by telephone. And this is quite standard abroad. I remember once I had to do a transaction in England, and it was a land transaction, and I was in a hurry. And I told the lawyer, can't we go to the land registry to go and do the search? And she said, you know, you'll be arrested. They will assume that you have a bad intention to come there. so she said, don't worry, let me call them on phone. Well, guess what? They met the deadline, they responded, and we did the transaction. And that's the sort of service, level of service that we're talking about. So, and I think the other issue about transparency to boost investors' confidence, I think that has been dealt with under the presentation on corporate governance. The rescue provisions, I just want to add that there are two new business rescue provisions that have been added: administration and the company voluntary arrangement. And these are excellent provisions that now allows a company that can produce a plan that shows that there will be greater value for the creditors than in a restructuring than in a liquidation, to go to court and get a court order, and then they'll get a moratorium, etc., and other tools that will enable them to continue to do business. So this is excellent. But at the same time, if it does not succeed, then the company can be put in liquidation. The next slide, please. The netting provisions are likely to be controversial, but they are good from the financial contracts point of view, subject to the fact that there may be need, if you compare it to what is happening internationally, that in putting the amendments into CAMA, they did not include the possibility of suspending the netting arrangement, particularly in a bridge bank situation. where it is possible that by enforcing netting, you may actually lead to a domino effect that can enhance the collapse of a bank. So at times, you may need to suspend the netting arrangements over a weekend so that a bridge bank can be incorporated to take over and continue with those obligations. So subject to that, there may be need, and that can be done by regulation possibly. So that having been said, there are certain, just looking at our ecosystem over and above the provisions of CAMA, you would find that there's need to develop the system of credit information and credit reporting. And this has been achieved in Nigeria with the Credit Reporting Act of 2017. So there's a lot of progress. We are seeing a lot of litigation coming on now where people are suing banks and saying, oh, why did you put my name in the database of the credit reporting? Because they tried to go and get another loan from somewhere without disclosing they are owing another bank. And so the system is already working very well. That means that people will become more disciplined, and then it will be more reliable when you give credit, and that will help the ease of doing business, because those bad creditors pollute the system, and therefore make it more difficult for the good businessmen to obtain credit in order to do business. So credit reporting and credit information management is very critical to ease of doing business, and we're making progress in that sector. And then transitioning from manual to electronic filing with respect to tax payment is one of the issues that have been identified by the World Bank as something that is, facilitates ease of doing business. And everywhere else in the world, most of, at least in the high GDP countries, most people just file their tax returns. First, it's on voluntary compliance, which is actually the basis of our own taxation in Nigeria too. You declare your tax, and you file mostly. Okay, a few people in the formal sector, they deduct your tax every month from your salary, but the vast majority of people are not employed in that manner. So the vast majority of people are entrepreneurs and business people who at the end of the year declare their tax, fill a form. It should be done electronically, and you fill it electronically, pay electronically, the government will get more money. We need to make more progress with electronic filing and payment of tax, which we haven't really fully achieved in Nigeria. Then automation of land acquisition and transfer. This is ongoing. We hear about different systems of different states, Federal Capital Territory trying to reform their land information system with new technology like blockchain and things like that. It should be able to be done in such a way that title can be transferred by a mere statement made by a qualified lawyer, say, entering into the system and saying that this transaction has been concluded, and then the transfer is done. Now, already you can secure interest in Nigeria under the Secured Transaction and Movable Assets Act 2017 by simply making a statement. The bank will file a statement, what is called a financing statement, into the National Collateral Registry. So with respect to movables, that is already possible. But with immovables, it's not yet possible for title to be transferred based on a main statement that is made by a qualified professional into an electronic system, And all these CFO and deed of assignment and the rest, they don't need to be held by the government. The lawyers can hold that, in their offices as evidence of title and transaction which they did. But the actual transfer should be electronic, etc. So we have a lot of challenges, and today it takes too long to transfer title. And then the employment law is very important because, without certainty as to contracts of employment, particularly from the employer side, you find that many companies will find it difficult to invest in Nigeria because, the issue of employment law and then the consistency of the jurisprudence coming out from the National Industrial Court needs to be looked at. There are so many write-ups and articles on it. And we really need to reform it by legislation, because if one were to depend on the jurisprudence that is coming out from the courts, then we may have a lot of challenge in terms of ease of doing business. Then dispute resolution is talking about enforcement of contracts. You know, if you look at enforcement of contracts in Nigeria, you look at the time it takes to enforce contracts. And there are a couple of World Bank research has shown that it takes maybe 3 to 5 years in Nigeria to enforce a contract, which is not good enough. So we need to improve our court system, etc., and make it very easy for people to get justice and enforce contracts, and that would improve the ecosystem of doing business. Thank you. The next slide, please. The next slide, please. Okay, so the CAMA 2020, therefore, is a major step towards improving the ease of doing business. But I should say from my experience, there's still some challenges in terms of speed and time, you know, it takes to get things sorted out with, for instance, we're involved in an acquisition that occurred a year ago, and we're still in the process of filing papers and coming up and down with CAC. A year after. It's very difficult to explain to foreign investors why is it taking so long to regularize the paperwork for that transaction. So we need to work very hard to improve the efficiency, both within the CAC and also the general ecosystem. Well, if you do the analysis, it's clear that this CAMA 2020 is leading to the inevitable success of the reform process that will improve the ease of doing business. And I think that if you look at the other recent successes, the Credit Reporting Act, the Secure Transaction in Movable Assets Act, the Federal Competition and Consumer Protection Act, which has moved competition law issues and including merger control issues from the Securities and Exchange Commission to a more dedicated organization, the Competition Commission. And if you look at the entire ecosystem, what is happening in the ecosystem, and if you go even backwards a little bit and look at the NIPC Act, where the government, you know, gave a standing agreement that they would arbitrate with any foreign investor in Nigeria under the NIPC Act, you find that Nigeria is ready for business. In fact, I am hopeful that we exceed the 70, number 70 in the index that the president has predicted by 2023 if we enforce the provisions of CAMA 2020 together with the rest of the ecosystem. So 4 critical areas are standing for me are electronic land transfer system, as I have said, you know, electronic filing of tax, you know, which will generate a lot of money for the government, effective dispute resolution, and then the personal bankruptcy reform. So there has been some reform with respect to company insolvency, but our law with respect to personal bankruptcy is still not good. It doesn't encourage people to go for personal bankruptcy. The discharge provisions are not very encouraging, and also the conditions for you to obtain the bankruptcy order are a bit onerous. So there's really need for reform in that area, and I think that if we consistently follow the agenda for ease of doing business, that Nigeria would release its energy in such a way that would continue to dominate business, not just in Africa, but we can create institutions that will become world players. What we want to see is more Nigerian companies that can play globally, that can be listed on the New York Stock Exchange, London Stock Exchange, and also many of these other companies coming also to list on our stock exchange. It is doable. It is doable if we really pursue the provisions of this law, and we encourage corporate governance and allow the law to work by completing the ecosystem that will make it to work effectively. Thank you very much.
Thank you, Leonard Silk, for your paper. I think it has given us a different perspective on how we view the new CAMA 2020 with a sense of positive approach. We thank you for taking out the time to give us this well-detailed paper. We'll be diving into the Q&A session immediately, so we can conclude in time. And the first question will be directed at Mrs. Gloria Ogu. Does the Act bestow on the Board of Trustees the power to dissolve the elected executives? It's a question from Mary Urai.
Thank you very much, Amlade, for that question. The Act is not, it's quite silent on that. However, it makes provision for the constitution of an association under Section 827, whereby the constitution of such association under Section 827 sub 1 part number 4 allows that constitution to state the number of persons who would constitute the governing body, as well as their appointment and removal and the powers of such governing body. In other words, the constitution of every association will guide as per the election, the removal, the replacement of elected executives in any governing body. Thank you.
Thank you very much, Mrs. Ogu, for your response. And I hope she has done justice to your question, to the participant who raised that question. I think one particular aspect of the new CAMA 2020 that has raised a lot of controversy is the part of the incorporated trustee. And the participant is asking a question which I will be directing at the Leonard Silk. Sir, a participant wants to know, considering the enormous power given to the Registrar General as it relates to religious bodies, what are checks put in place to prevent arbitrary use of such power?
Thank you very much. I think the managing partner in her presentation did review the checks and balances that are there in the provision. I think that, it is right for people to express some concern, but I think we should look at the provisions of the law very critically. First is to determine whether the law is specifically targeted at a religious organization. Well, in my view, looking at the law, it doesn't seem to be targeted specifically at religious organizations. It is targeted at tax-exempt organizations. In other words, that the government takes the position that, well, if you are not going to pay tax, which you are supposed to pay if you're doing business, then we need to be able to look at your operations to see that you are focused on those charitable objects which you say that you are doing. Otherwise, if you are not doing those things, then we should be able to make you to pay tax on it. So that's the first one. Two, that because these organizations collect monies from people with promises of what they will do with the money, then there is need for some regulator to look and to see whether they're actually doing that thing they said they were going to do. So there is a relationship between those who donate to these organizations and those who hold the money, and then the object which is to be achieved, for which the government is also interested, because these are charitable objects that would supplement the work of government in assisting people that need it. So it's not 100% targeted at religious organizations. It just happens that religious organizations fall within this category. And if you look at international best practice, in the UK, you have the Charities Commission, which plays a similar role. Now, people have made the argument that this Charities Commission, the way it is constituted, is a bit more independent and different from the way the CAC is constituted. Some people make the argument that these charities or religious organizations do not have representation on the board of CAC, and that CAC is focused in terms of the structure of the board more towards commercial businesses and not incorporated trustees. Well, the truth is that the CAC has always regulated incorporated trustees anyway before today. And whilst there may be some merit to see that the constitution of CAC will be in such a way to accommodate those that have experience in this area, the reality is that that does not take away from the argument that there's a need for some sort of regulation. So that's on the regulatory policy issue, that any way you look at it. If you also go to the US, the regulation of tax-exempt organizations, which include churches and mosques and any of those religious organizations, is still tax-based. It's based on the fact that, well, if you're not going to pay tax, then we will subject you to a certain level of scrutiny to be sure that, you know, the government has taken the right decision in exempting you from paying tax. So, I was saying the other day that, you know, in another webinar, that I attended a course at Harvard, and almost half of my classmates are people who are working for charities. Their audit committee, to tell you how seriously they take it, they make sure that they are trained. They have audit committee. They run like companies. So you talk about the business of philanthropy, you know, it's a whole business, you know, so it's run like a corporation, and they maintain the same level of corporate governance, etc., as any other company. And directorship or being on a board of incorporated trustee carries the same level of scrutiny as with the regular commercial business. And that's how it's done in America from my experience, and also in Canada from my experience. So what is happening is that that level is rising as well in terms of governance in Nigeria. Again, as Justine said, that they're trying to bring in best practices into Nigeria. People say, oh, Nigeria is different, but how different is Nigeria from the rest of the world? You know, we want to compete globally. We want to set up institutions that can go across border. Today, our banks are operating. In fact, one of the biggest institutions in Africa in terms of a bank, we have a bank, the Nigerian bank, that has branches in about 38 countries in Africa. And Nigerian businesses are going abroad, and they are not going to go on different terms. They have to be able to play like global players, you know, and hopefully one day would have even Nigerian NGOs that can raise billions of dollars to deal with certain issues. They will be subjected to the same level of scrutiny when they go to another country to raise money. So it's something that we need to recognize that is happening. So so having justified the regulatory imperative, then you go to the so how do you manage our peculiarity in Nigeria? You know, how do you manage it? Then you go into the law and say, so what are the checks and balances that have been put to ensure that this whole thing is not abused? You find that it requires a court order. It requires a minister's approval. So there's some level of political discretion there. So, and then intervention of a court. So I think that these two, for now, could provide sufficient check to any likely abuse of that power by the commission for now. So that's my own view. But what the advice I would give to any charity is to begin to prepare. And this is where we say that, you know, if you were doing a charity and you didn't have a proper secretary, you were not keeping your audited accounts, you don't have an audit committee, you are not running it the way companies run, then you have to begin to change your mind about the future, about how it's going to be. And that will mean more work for professionals, for lawyers, for accountants, etc. In the system. So this law actually will generate a lot of work for lawyers. Unfortunately, that Folari is not here to speak to it, you know, but these are the areas of connection between this law and the practice solicitors. Thank you very much.
Thank you so much, Leonard Silk. We have expended our time, and but we just want to tell you that we have your information. For as many questions as you want us to answer, kindly stay in touch, and we'll do well to address your questions. But Leonard Silk, you gave a very detailed and very expansive explanation to your question, and I think that covered a lot of questions that would that have been on the minds of a lot of persons regarding incorporated trustee under CAMA 2020. Just before we call it a day, I would like to direct a question to Mr. India, which is how can we expect a guideline from the Commission? How soon can we expect a guideline from the Commission? And how have the Commission ensured participation and contributions from stakeholders to ensure a comprehensive CAC regulation and guideline? Because just as we have it, the regulation play a very key role in ensuring that this act comes into force seamlessly, especially with the operational day-to-day operations of CAC. So, Mr. Justin, I would like to know, how did the CAC involve stakeholders, and what is the time frame we're looking at in fully implementing any regulation or guideline? Thank you, sir. Mr. Ndia, you need to unmute.
Can you hear me now?
Yes, sir, we can hear you now, sir.
Okay, okay. Like I said earlier, the board will be meeting next week to consider an in-house draft regulation that was earlier prepared. So as soon as it is cleared by the board, it will be exposed to members of the public for comments. So the thinking is that before end of November, we'll have a draft regulation ready for presentation to the minister. So that in summary is what I said. And like I said, we don't want to make it a secret document. It will be exposed to members of the public for their comment. And the commission will also be sensitive to the comments that will come from the public. So it is expected that the comments will inform a further review of the draft regulation before it is forwarded to the minister for enactment as subsidiary legislation. So that is in summary what I want to say on issue of regulation.
Thank you so much, Mr. Justin. I think we feel a sense of security when you made the point about transparency. I think that really puts every one of us in a better position to know that we have a role to play, and we can as well lend a voice in ensuring that we have a regulation that everybody will be okay with, and will be able to fully utilize the beautiful innovations that have come under this CAMA 2020. My final question will be going to Mrs. Idigbe, so we can call it a day. Quickly, Mrs. Idigbe, a participant would like to know who are relatives as defined under section 275 of the CAMA 2020.
Thank you very much. We don't have a definition of provision in the CAMA for this, but generally, I think we could look at the provisions and the definition as it is, generally, ordinarily, and that would include anybody who is related to somebody either by blood or by marriage. So in that regard, it may be your parent, your parent-in-law, your uncle, your auntie, your children. So I think that's, the best way to, for me to explain who are relatives under this provision. So somebody related to you, either by blood or by marriage. Thank you.
We are most grateful for your response, and I hope that answers the question of the participant who asked. I want to take out this moment to say a big thank you to all the speakers for taking out time from your busy schedules, and all participants too, from your daily schedules. You took out time to attend this webinar. I want to urge you to stay in contact with the firm by visiting our website, www.punuka.com. Also, you can follow us on social media at Punuka Attorneys on Instagram, on LinkedIn, and on Twitter as well. Engage us. We would like to know what your questions are, and also ways that we can contribute to ensuring the smooth administration of the CAMA 2020. Also, follow us for other webinar series by our various practice group and the new business and regulatory practice group as well. Your questions which you left in the comment section will be attended to, communicate with you personally on some questions you've raised. But I believe that with our exhaustive and answers to some of the questions, it cut across a lot of other questions that some of you wanted to ask. Before we go, I'll call on the senior partner to give any final words before we leave the webinar. Thank you very much.
Thank you. Just to thank everybody for attending, and also I can see some in the chat box some proposals for us to partner to further this discussion. We'll follow up on those, and some questions about the access to the slides. This webinar has been recorded and will soon be uploaded on our website, so you'd always have access to it in case you require it for your work. Thank you very much.
Thank you very much, everyone. Have a wonderful week ahead. Thank you.
Thank you. Goodbye.
Bye-bye.